has been completely resolved. And finally, there's a notice which has been put up by the registry today. There was a phishing attack on our website of the Supreme
Yes, my
Court.
lord, yes.
So please be careful in the sense, don't click on that website, or don't use that for a monetary transaction, because that will just be, that's the whole object, to get people to
Share the
funds.
details or something.
Yes, my learned friend start, I just wanted to find out about the faculty member, my learned friend. Faculty member who was suspended.
Oh, Mr. Bhatt. Mr. Attorney, what is
some advice was given. What is the effect, my lord, can be responded to? We'll just take instructions, my lord. We
just ask somebody there. I hope
yes,
they have.
I got it. Only thought Mrs. Gawai's, we can give a healing touch to Mrs. Gawai's.
Lord, I was to answer, my lord, those two questions which I said that I will give a detailed answer, my lord, on
Yes.
the elections, my lord.
Yes.
Lord, so far,
I'm sorry, my lord. I didn't want to. I was not unmuted. I've been very kindly allowed by Mr. Dwivedi to come in after the attorney, because I have some personal difficulty on tomorrow.
Yes, my lord. Mr. Salve had some difficulty, my lord, and Mr. Dwivedi was
Between
really
all of
gracious.
you can
Really
adjust the
gracious,
order.
my lord, that he didn't object, and I'm
So
really all
that's
thankful.
a matter of internal adjustment for all of you. Now, Mr. Solicitor, what do you have to?
Yes, my
you
lord,
have to
on the
make?
question of your lordship's first question, when the elections can be held. Well, the central government response is, my lord, the central government is ready for elections at any time now. Till date, updating of the voters list was going on, my lord, which is substantially over, my lord. Some part is remaining that election commission is doing. But we are, I'm sorry.
Yes.
But when would be the call taken by the State Election Commission and, of course, my lord, Union Election Commission together? But there are 3 elections which are due.
Yes.
Lord, for the first time, the 3-tier Panchayat Raj system is introduced after 2019. So the first election will be that of Panchayats. District Development Council elections have already taken place, but Panchayat institutions. That is for the rural areas, my lord, your lordships are aware, under Chapter 9 and Chapter 9A of the Constitution. Lord, your lordships, I informed your lordships that the Leh part elections are over. Kargil, for my lord, the Hill Development Council, election is at the end of this month. The process is on, and the election is, I think, 2012 this month, my lord, 2023.
For Kargil also, you call it the Hill Development Council.
Hill Development Council.
For both, you call it.
For both Kargil and Leh. These are the only 2 parts in, my lord, Ladakh UT. But this is the position as on today. And the second election would be municipality elections. And the third would be legislative assembly elections. It's UT with legislature, my lord. Your lordships were taken through that, my lord, except 2 subjects, law and order and police. This is based upon the figures which we have, the terrorist initiated instances are reduced by 45.2%. I'm comparing 2018 situation with 2023 situation.
Nothing to do.
But infiltration, which was a very major problem in Jammu and Kashmir, reduced by 90.2%, 90. Law and order events, substantially the stone pelting and other events, reduced by 97.2%. These are all figures relevant for the purpose of decision.
Minister, this is not for our purposes really relevant. The only
No,
one.
for the purpose of when to hold the election. As on date, this is the position. That's what I'm pointing out, and these are, everything is on affidavit. I'm not. And security persons casualty is 60, reduced by 65.9%. These are the factors which agencies would take into consideration. But fortunately, affected the elections most were stone pelting incidents and regular call of Bandh or Hartals, means hospitals, schools, every institution where a common man is concerned. From 2018, in 2018, the stone pelting was 1767. It is nil now. Not just because of effective policing or security personnel, but because of various steps, like gainfully employing the youth, etc. They were misled by the secessionist forces, by the forces outside the country, etc. And organized bandhs, which were in 2852 instances, organized bandh, call of bandh by secessionist forces. Nil.
How many?
In 18, they were 52. Now, it is nil. Now, Lord, so far as statehood is concerned, Lord, I have already made a statement before your lordships, but that apart, the statement of the Honorable Home Minister on the floor of the House, that UT is a temporary phenomenon. We are dealing with an extremely extraordinary situation. The state will have to be infused with several things so that it becomes a state, so to say. Lord, those actions, Lord, are initiated, and Lord, I may give some, Lord, instances how it is progressing, Lord, to become a state, because I am unable to give, Lord, exact.
You can wrap up in about 2 minutes now.
I'll just, Lord, give me 2 minutes. Your Lordship did not write. I'll place it on record. Lord, for the purpose of ensuring that the UT becomes complete state, Lord, as it should have been like any other states, the central sector scheme investment is 28,400 crore. The investment proposals from other than central schemes is 78,000 crores. And till date, the actual investment made is 2,153 crores. Your Lordship did not write. I'll write it down, and, my Lord, and give it to your Lordships. Lord, several initiatives have taken place, and as a result of which the transparency, Lord, has shown us that the projects have risen from, and these are all, my Lord, statements on affidavit I have made, 9,229 in 2018, and now in 2023, it is 92,560. More and more people are participating in e-tendering and several e-initiatives, my Lord. And therefore, my Lord, that is also giving a boost, and the youth is gainfully employed. My Lord, the peace doesn't come merely by police action. There are several schemes which are introduced, several beneficial projects which are introduced. I'm just giving a bird's eye view, my Lord. And out of 53 projects under the Prime Minister Development Package, worth 58,477 crores, out of 53, 32 are completed. this is how progressively, my lord, we are proceeding to make it a complete state. But I am unable to give, my lord, my instructions are the exact time period right now about the complete statehood, while saying that union territory status is a temporary status because of the peculiar circumstances the state had passed through with repeated and consistent disturbances of decades. Well, it might take some time, and we have shown, my lord, the progress also. Very, my lord, it was heartening for me also to note that only in 2022, January 22 to December 22, 1.88 crores tourists visited. The lordships are aware, the main industry so far was tourism in Jammu and Kashmir. Now, my lord, industries are coming. And till date in 2023, 1 crore tourists. It gives employment, it generates employment in various sectors. My lord, one, there is a tourism boom. So these are the steps which are being taken by the central government, which can be taken only if there is a union territory. And I have shown the Reorganization Act. It is having all trappings of the state. But the election, the government is ready. It is for the Election Commission of India and Election Commission of the state to take the call. Out of three, which election to take place first and how. The updating of the voters list is complete. Some part is missing, my lord, but it is yet to be over. It's in the process. It would be over, my lord, in a month or so, my lord. That's what I'm told. Thereafter, my lord, they will take a call considering the overall situation.
You'll be wondering what the Chief Justice is doing is on a phone from the court.
Yes. This is my question. Learning technical assistant.
But I just want to know whether your lordships are taking into account these facts, because whether that's extremely relevant from our point of view. Because if your lordships had said earlier that subsequent facts will not be taken into account, we are dealing with the law, we are dealing with these facts.
Mr. Sibal, these facts on what they have said would have possibly no bearing on the constitutional issue which has been argued.
But even otherwise,
But-
because we have to counter those facts, Mullah.
We had asked them a question on the roadmap for holding an election.
That's fine, Mullah.
That's what they have responded.
But Mullah,
That's what, Mullah, in my
That
argument
has-
on merit.
But our decision on the constitutional issue has to be on constitutional.
But Mullah, these facts will go into the mind of the court because they are trying to show as to how this enormous change has taken place for the benefit of the people of Jammu and Kashmir. If you have 5,000 people under house arrest and 144 throughout the state, there can be no one. So Mullah, my request to your lordships is, please don't enter into this arena, because we will have to counter it with all kinds of facts, Mullah, which I don't think is necessary for this court.
The nature of the development work which the government says has taken place post August 2019, this may not be of relevance to your constitutional challenge. And therefore, when they respond to the constitutional challenge, that has to be dealt with independent.
I didn't rely upon it while
But
answering
Mullah,
on
these
merit.
facts, if they come into your lordships, Mullah, as part of the record, then that has.
I think, Mr. Sibal, what the solicitor, to be fair to the solicitor, what the solicitor was saying is that the roadmap to full statehood would take a little time.
That's obvious.
Right now, that they are the development. There, his submission is that right now development work is taking place. Some stability has to be brought about. This is not a permanent arrangement, namely the UT status. They envisage that it will be a movement from UT to statehood again. We can't give you a fixed point of time when we will restore statehood, but they have told us the process which they are following on the path to. Full
I have
statehood.
no objection to
That-
that statement. I have no objection.
And that's how we read it.
Yes,
actually.
well, if any other fact that you bring to your lordship's notice has no bearing, because I'll have to count
Mr.
it.
Solicitor, Mr. Attorney, we take it that what you said, Solicitor, a short while back, is along the lines what we said.
Yes, yes,
That this is-
answer the election and
The roadmap to
statehood
full-
query, not as a
Correct. I have
justification
no
for.
problems to that,
Mr.
Mullah.
Sibal also fairly says that he has no difficulty about that.
But
During my
he says
arguments
that
on merits,
this
I
has
never
happened.
relied upon.
This cannot be an answer to the constitutional challenge.
But even otherwise, it should
I
not
also,
be
Mullah,
into your
didn't,
lordship's mind,
absolutely.
Mullah, that these are great things that are happening, Mullah, because today, the kind of drugs that are happening with the youth in Jammu Kashmir is unbelievable. But I don't want to enter into that controversy.
Can I put it like this?
The
Neither,
unemployment rate is enormous.
Mr. Sibal, these are matters on which there can be and should be in a democracy policy differences,
That's right.
but that can't affect the constitutional
Absolutely.
answer to a constitutional
Therefore, Mullah,
challenge.
once you start placing these facts and Mullah, your lordship.
But therefore, we place those facts which he mentioned in the perspective of the roadmap to statehood. That's all, and nothing on.
This is
on
not
the-
a justification.
This is not a justification. It cannot be, from our perspective also, to the answer to the constitutional challenge. We'll have to address the constitutional
So your
challenge. on
lordship will
constitutional
allow me to
grounds.
place some counterfacts to that?
may
No,
I
it's
put
not
it like this?
necessary,
Mr.
Mr.
I had intervened that stage also when you
Yeah.
were saying, only for this reason that we wanted in a conspectus to understand when they look towards restoration of statehood.
No
To
problem.
which they made a statement that
That's no issue, Mullah. They say that will take some time. Your lordships will decide on that issue, Mullah.
And that's confined to our answer, our question to Mr.
But
Solicitor.
Bunds
We are
have
very
been
clear
reduced
on
to
this.
zero, bunds have
Neither-
been reduced to
but
zero, all
if you
that,
don't
much.
mind.
With respect, I say, your lordship should not even, those facts are not relevant for the purposes of your lordship's decision is all that I
And
say.
therefore, we had not taken that additional
Right.
affidavit which was sought to be filed at the inception of the record. And I don't think there's been any change in that
Thank you.
position.
I think it's better understood like this. Neither these statements nor their refutation, if need be, will enter into the question of determining the constitutional validity.
Correct.
So therefore, paraphrase it like that.
Yeah.
You don't want to put it like
And
that.
on that
Kindly
aspect,
see.
I also
on
didn't
that-
rely.
On that,
Kindly
Mr.
see.
Sibal, Mr.
It's for an
Attorney and Mr.
entirely different
Solicitor,
purpose.
I think there is a broad-based understanding on both sides that the constitutional challenge has to be answered on.
But
During my assistance on merits, I never relied upon
The
this.
problem is the following, these are televised, all this is being televised and all of this being recorded. So Mullah, these facts come on the record, they are part of the public space and people feel what a great thing has been done by the government. Mullah, this creates a problem. Well, that's why I.
That's why progress never creates problem.
I'm sorry.
Lack
Please
of
allow me.
offenses
All right,
do
Mr.
not
Sibal, we
create
got the
problem.
point. We got your point. I think we have clarified it.
Yes.
That the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should enter into the.
And they have not argued equity in defense to your constitutional challenge.
That's all, Miller. That's all.
Yes.
I suppose these statements are otherwise in the public domain.
No,
In elections,
it's
will
not
be
in the public
what's
domain.
happening in the- and therefore,
Mr. Attorney,
public
there's a
will
lot of-
consume it.
Mr. Attorney
because of-
General, you're meeting the constitutional challenge on constitutional argument.
Which I
We
did.
must
I never-
address this matter like any other constitutional
That's
matter as a
right. In the
constitutional issue
public-
which we have to
I can
confront.
raise a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you made, that's not part of the public space.
And that
You-
Mr.
then
Sibal
you-
has also clarified, there can't be any
That's
objection.
internal.
We needn't labor this issue, we are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement on the hard cases and not one single.
Only
Yes,
one
yes, yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. Well, that means the right people are in the house arrest.
5,000 people. Let's not make
Isn't it there?
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no buns. Why? How can there be buns when people can't even go to hospital? People could not go to hospital because of the bun. They died.
I wish,
Let's not go into all this.
Mr.
I
Sibal.
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I-
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
Absolutely.
the sense of objectivity which must govern an answer to a constitutional challenge. We request both sides, let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into the domain to try to color the mind of the judges. We've not done that. I don't know about that.
All right. Yes, Mr. Attorney.
Now, as I say that the famous principle versus rules and the hard cases thesis of Dworkin, one wonders we are not in a situation like this. We're leaving, taking off from where I left day 4 yesterday. There's a couple of digressions I would like to probably play before a lot because when you talk about the intent of a law, Wittgenstein, who co-authored with Bertrand Russell, and his famous philosophical investigation, he talks about a signpost. How do we know what a signpost means? There must be a practice of using the signpost and an understanding which develops over the using of the signpost. Without that practice and understanding, the signpost means nothing. So this principle has been used in various circumstances to bring closer. If there is an understanding about a law on the basis of a practice, then interpretation follows one course, one trajectory. But if there is a lack of understanding or conflict of understanding, interpretation heads in another trajectory. Therefore, when you are trying to understand the intent and connect with the content of Article 370, you have to keep in mind what went into the original author's making of 370 and what has happened over a period of time by the practice of using Article 370. So, a text sometimes, by reason of its aging and the use of the text, may demonstrate a certain practice which may show in a slightly different direction. That's why in the context of desuetude, two important principles come. A disuse plus a contrary practice. I don't get into the desuetude doctrine, it's not necessary for a purpose. I don't want to flag that. When you're trying to understand 370 in a perspective, we have all these complexities. It's not merely a case of reading the text, looking at the text and the context and arriving at a meaning. We are confounded by the practice of Article 370. whether in conformity with the original intent or in deviation from it. So the court is now called upon to look at the age of the text and the use of the text and how in current times the president understands both the original text and the use of the text, and the president now understands this is what I would like to do with the text. I left day for a study on this proposition when the president is not precluded for what I call the taking stock of what Article 370 has done over a period of time. This taking stock is written into Article 370. While we do that, how the president may take stock and how the court will be called upon to have a glimpse of understanding of what the president intended to do by taking stock. I just want to place 5-6 propositions in the context of construction against absurdity. These are all gathered from books on interpretation of statutes. Because the presumption against absurdity will, number one, avoid an impossible result.
Presumption.
It will also avoid an unworkable or impracticable result. I'll put them all together and hand it to your lordships now. It will also avoid an anomalous or illogical result. And connected to that is to avoid a futile or a pointless result.
What is the third one you said, Mr. Attorney?
First one is
No,
an impossible result.
no, third one.
Third one, an inconvenient result. An anomalous or illogical result. An anomalous or illogical result. The final one, I said a futile or a pointless result. All these will go into courts looking against the presumption against absurdity. So court will avoid a construction. It requires a person who that which is impossible. The doctrine of impossibility is contracted is different, but when it comes to textual impossibility or constitutional text, it may stand on a different footing. That's why all these principles have a certain importance in construing Article 370. I referred briefly the other day about this presidential poll judgment of your lordships. That is 1974 to SCC 33. Before I take a lodge to the 1974, it is a 143 reference in the context of holding elections. Before I take a lodge to that, let me make a few observations. It's not part of the PDF because it's not part of the compilation.
Yes.
So we are trying to look at the proviso to clause 3 of Article 370.
So which is the part of this judgment you want us to see? Para?
I'll give the paragraph, your lordships.
We have it opened up and you have it on the screen.
Yeah,
as
we
well,
have paragraph. I'll just summarize the proposition was the presidential election had to be held. Gujarat Assembly was dissolved. Therefore, the electoral college was incomplete. So the argument was without the electoral college becoming complete, you can't hold a presidential election. Court says I read Articles 55, 54, etc. and come to a conclusion. It's a mandate that you must hold the election before the president term expires. Right. Therefore, the lack of the electoral college not being complete will not come in the way. So that unless you fulfill that impossible, that the court says you must, the argument was, you must have the electoral college completed before you hold the elections. For the mandate of holding the election.
You're stretching that to our case because According to you, the conditions for the application of the proviso to Article 373 are absent, and therefore the substantive part cannot be rendered into disuse merely because of the
You're
absence of the
absolutely
Constituent
right.
Assembly.
Therefore, I come to the arguments on the other side currently. Now, there is no principle in
What's the para?
jurisprudence.
Just give us a small para so we are then done with this judgment.
These paragraphs 5, 4, 5, 12, 13, 15, 20, 21, 29, and 47. There they look at the impossibility of performance.
How
So what
do
I'm
they,
trying-
how do they formulate it? Just let's see it in a moment.
I'll presently come to it.
It's 7 judges, so we can just look at maybe that one or two sentences and how they formulate it.
Give me paragraph. Also, just see paragraph 4 and 5. Paragraph 4, page 47 of the running page 47 of the judgment. They come to a conclusion that the conclusion part of paragraph 4, it shows that the time to hold an election to fill a vacancy is also mandatory in character. Then,
Actually, the
paragraph 15, that's important for our purposes.
Some of this suggests. So let's take it to
Page 49, running page 49 of the judgment, paragraph 14, last sentence, and then thereafter paragraph 15. Paragraph 14, the last sentence. Sentence beginning, the necessity. Justice Scholars got that paragraph.
Only 26 pages.
stop you from. Strike all that.
Paragraph 14, last
49,
sentence.
page 40.
The sentence beginning the necessity for completing the election.
14.
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interests, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so-and-so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentia excuse et legem is intimately connected with another maxim of law, lex non cogitata impossibilia. Impotentia excuse et legem is that when there is a necessity or invincible disability to perform the mandatory part of the law, that impotentia excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constituent Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance the way it commands you to perform.
Say it's like an.
Yes.
29. Paragraph 21. An argument that it shall not be done is available in paragraph 21. Paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assembly of the state. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assembly of the states to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It was also said that if the states were denied the right to cast votes at election, the parity between the states and the union would be disturbed. All that argument is considered. And kindly turn to paragraph 29. Again. It was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state were denied such a right, it would be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso to Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener that Articles 54 and 55 read with 368 would be a key to the interpretation of Article 62 that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state where the Assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of dissolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state will not have been elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Karake Supra There are vacancies in the electoral college by reason of the fact that there are no elected members of the Legislative Assembly of the state where the Legislative Assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the president or suggesting the election to fill the vacancy caused by the expiry of the term for the office of the president could be held only after the election Legislative Assembly of the state where the Legislative Assembly is held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is at page 57, landing page 57 of the judgment.
Yes, yes, Mr. Attorney General, we've seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the president is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like, I have done my duty, therefore I exit the scene. Clause 3 still remains an important part of reaching the exit stage. The only question is, how do you reach it? What is the more fairer way of reaching that exit stage? What consideration will weigh the president in exercising the power under clause 3? One possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. One way of looking at it. Suppose we don't want to go that route. Then the president could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the president may take into account. The other way is, should I try to follow a precedent set by the president earlier by recourse to Article 367 and recourse to Article 371D? So extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the president has done that earlier. I'll come to those details. There are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It is not a legislative function at all. Give the reference. Video page. And then we have a key in Article 356, 1B, that after a presidential proclamation, President can declare the powers of the legislature. It doesn't say the legislative function. He talks about a compendium of powers available to the legislature, and that the president takes over to hand over to the parliament. For the sequence of events which was contemplated in a situation like this, where there is a void,
So now the
there is an impossibility of complying with the proviso to clause 3. And how do I fill that void, if at all it's a void? I said the president could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modifications. But the president does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. Once it is a non-legislative